Imagine waking up to the headline, U.S. forces capture a sitting foreign president now arraigned in New York. Shocking? Yes. Unprecedented? Not completely. But what happens in U.S.? Courts next could reshape international law and how countries chase fugitives. Today, we'll follow the January 2026 capture and federal arraignment of Nicolás Maduro to answer a single burning question. Can the United States try a serving head of state, and under what legal rules? Stay with me, because the answer is messy, legalistic, and loaded with international consequences. Hi, welcome to Shadow Docket, Courtroom Files. I'm your host. Quick disclaimer before we dive in, this is an educational explainer only, not legal advice. I'm summarizing public reporting and legal principles as of the 6th of January 2026. Consult a licensed attorney for case-specific guidance. In the next 12 minutes, you'll get the operational and legal basis for the arrest, why Manhattan's Southern District of New York is the forum, how sovereign immunity might work or fail, and what evidence and constitutional fights will decide whether this case gets to a jury. Plus, the broader precedent this could set for extraterritorial captures. Later, I'll explain why a 1900s Supreme Court line of cases might make the U.S. courtroom more hospitable to prosecutors than many expect. But first, how did we get here? Let's start with the facts. According to public reporting, U.S. forces captured Venezuelan President Nicolás Maduro in an operation on the 3rd of January 2026 and transported him to the United States. On January 5, he and Cilia Flores were arraigned in the U.S. District Court for the Southern District of New York and pleaded not guilty. The criminal indictments date back to 2020 and include serious counts: narco-terrorism, conspiracy to import cocaine, and weapons offenses. The Department of Justice had those indictments on file, while the executive branch apparently took operational steps to seize custody abroad. Now, here's where it gets interesting. The United States doesn't have a single statute that says the president of a foreign country can be picked up by U.S. forces and brought to New York for trial. Instead, this is a mix of domestic criminal law indictments charging federal crimes and executive authority to take extraterritorial action. That authority can come from a mix of statutes, Article 2 powers, and military or intelligence operational planning. In short, DOJ charges. The executive secures the defendant. Simple on paper, messy in reality. Why the Southern District of New York? SDNY has long been the go-to forum for international narcotics, money laundering, and terrorism cases. The 2020 indictments naming Maduro and associates were filed there, and once custody is secured, the practical step is simple. Bring the defendant to the district that has valid charges. The charges are straightforward federal statutes: narco-terrorism counts, conspiracy to import controlled substances into the United States, and related weapons offenses. Those are federal offenses with extraterritorial reach when alleged conduct targets the U.S. market or national security. But here's a wrinkle. Forum selection isn't only about convenience. Prosecutors weigh evidence, witness access, and the strength of classified information. If prosecution relies on intelligence collected abroad, classified sources and methods become core litigation, and that pushes the case toward SDNY's experience with SIPA, the Classified Information Procedures Act. So SDNY isn't just politically symbolic, it's doctrinally useful. Wait, can the president of another country be arrested at all? Keep listening, the immunity question answers that. Here's the legal sledgehammer everyone's waiting for: sovereign immunity. Under customary international law, a sitting head of state typically enjoys personal immunity for official acts. That immunity can prevent foreign courts from exercising criminal jurisdiction. So, could Maduro invoke head of state immunity and get this case tossed? The answer depends on two critical facts. First, recognition. Immunity often tracks whether the accused is recognized by the prosecuting state as the lawful head of state. If the United States had already withdrawn recognition of Maduro before the capture, and public reports suggest U.S. officials had described his regime as illegitimate in prior years, that undermines a broad immunity claim in U.S. courts. Second, nature of the acts. Immunity covers official acts, but not private acts like ordinary crimes. Prosecutors will argue the narcotics and weapons charges are not official state acts and therefore not shielded. Even if the U.S. court rejects absolute immunity, defense counsel can raise other doctrines, functional immunity for certain acts, or argue that the actions alleged were undertaken as part of state policy. Those are hotly disputed issues, and they'll probably produce immediate pretrial motions and appeals. There's an older Supreme Court line that might be more decisive than immunity Ker and Frisbie. Ker v. Illinois and Frisbie v. Collins essentially say that forcible or irregular capture, even abduction, does not automatically prevent U.S. courts from trying a defendant. In Frisbie, the court declared that the power of a court to try a person is not impaired because he had been brought within the court's jurisdiction by reason of a forcible abduction. So if U.S. forces grabbed Maduro in Caracas, that fact alone does not guarantee dismissal. But Ker Frisbie is an absolute. Lower courts and scholars have recognized exceptions, especially where the government's conduct violates fundamental due process or where there are extraordinary international law concerns. The doctrine gives prosecutors a strong starting point. But defense teams will press for narrow readings and try to create a judicially manageable line to exclude the case. Will the court view this as a run-of-the-mill Ker Frisbie abduction or as an extraordinary act with international implications that triggers a due process or political question exception? That decision could decide whether the case survives to discovery. Evidence is where the rubber meets the road. What can prosecutors offer from a military operation? Physical items seized at the scene may be introduced if chain of custody is preserved. But intelligence-derived evidence intercepts, informant reports, signals. Intelligence raises huge issues. The government may invoke SEPA to protect classified sources and methods, limiting what is disclosed in discovery and how witnesses testify. Constitutional claims also matter. The Fourth Amendment's reach abroad is complicated. Courts apply a mix of territorial and reasonableness tests. Fifth Amendment protection against coerced statements still applies. Any interrogation that was coerced, involuntary, or amounts to torture would be excluded. Hearsay, authentication, and chain of custody fights will dominate. Courts have often admitted evidence obtained after irregular abductions unless the defendant shows a due process violation, think brutal torture or deliberate fabrication. So prosecutors will likely rely on Ker Frisbie momentum and SEPA protections, while defense counsel will try to isolate anything that smells like coercion or classified cover-up. This case is not happening in a vacuum. Venezuela, allied states, and international bodies may challenge the seizure at the International Court of Justice, the Organization of American States, or the UN. Security Council alleging unlawful use of force and violation of sovereignty under the UN Charter. Expect diplomatic protests, potential sanctions, quid pro quos, and countermeasures from Venezuela, economic, legal, or retaliatory seizures of U.S. interests. Will an ICJ or international forum block a U.S. domestic prosecution? Not directly. International courts can issue rulings about the lawfulness of the use of force and order reparations, but they usually lack direct power to tell a U.S. federal court to dismiss a criminal prosecution. What international adjudication can do is complicate U.S. foreign relations and increase political pressure on prosecutors and the executive branch. Could the international backlash force a plea deal or political resolution rather than a full trial? It's possible, and that becomes part of the calculus for DOJ. On the defense side, expect a multi-front strategy. Immediate motions asserting head of state immunity, suppression motions challenging the legality of the seizure and the admissibility of evidence, Fifth Amendment challenges to any statements, and political question motions seeking non-judicial resolution.